A quiet courtroom turned into a political storm today. What was meant to be routine has now sparked headlines about hidden tapes, weak evidence, and Trump's fury echoing through Washington. Before we dive in, comment where you're watching from and don't forget to like and subscribe.
Ken, I'll go first to you. Continue to walk us through what we can expect from this arraignment. We expect it to get underway any second now, right?
That's right, Allie, and this is one of those courthouses where no electronic devices are allowed inside, and so we won't know exactly what's happening until our producer comes out of the courtroom. But the judge in this case, Judge Jamar Walker, was actually a former prosecutor in this office in the Eastern District of Virginia, a Biden appointee, will preside over these pro forma proceedings where the charges will be read to the New York Attorney General, that charge of bank fraud and the other charge of lying to a financial institution. She'll have a chance to enter a plea. She can either do that herself or her lawyer will do it for her. There'll be a discussion of her rights, a discussion of terms of release, and then also some talk about the two motions that her attorneys have filed trying to attack this case. And it's worth also pointing out that we have some new reporting, first reported by ABC News, but that we've learned about a memo that was written by the original prosecutors in this case, two of whom have been fired, that seems to undercut the already weak evidence in this case, suggesting that, for example, the potential benefit that James got from this better mortgage rate on the second home amounted to as little as $15 a month. And this memo also pointed out that the rules around qualifying for a second home versus an investment property are vague, and therefore it would be problematic to win a conviction at trial. That was presented to the prosecutor. Obviously, they've chosen to move forward with this case using a prosecutor, Lindsay Halligan, who has never before prosecuted the case, was an insurance lawyer. And so here we are arraigning the New York Attorney General on these charges of mortgage fraud.
Yeah, and I think it only continues to underscore the steep climb that prosecutors are going to have, including Halligan, in presenting this case. But Lisa, what do we know about the judge in this instance, as well as his record, and how that might be applicable here?
Well, Allie, Judge Jamar Walker has only been on the bench since March of 2023. He was nominated to the bench by President Joe Biden. And prior to that, he served as an assistant U.S. attorney in the same district where he is a judge, the Eastern District of Virginia. He was an assistant U.S. attorney there for 8 years. Prior to that, he was an associate at a Washington law firm. But he is steeped in Virginia. He was born and bred on the Eastern Shore of Virginia, a graduate of the University of Virginia and its law school. The other thing that we know about Jamar Walker is that he is the first Article III judge in Virginia to identify as openly gay, lesbian, bisexual, or transgender. And the other thing I want to point out to you is that he is exceptionally young. He is 38 or 39 years old. I can't tell exactly which, but based on his date of birth, this is a very young judge who, again, has prosecutorial experience in the district where he is now a judge, where he is overseeing a case where the U.S. attorney who alone brought the indictment herself has never had any prosecutorial experience. This is a district that is proud of its record. As you know, they refer to it as the rocket docket because it handles criminal cases particularly expeditiously, which means that the competence of prosecutors and their speed and fluency with the federal law are both important to their overall success. Jamar Walker, therefore, may be a tough judge with respect to what has gone on in the Eastern District of Virginia, even thus far in this case. I'll be really interested to see how the arraignment goes this morning and if, like Judge Michael Nachmanoff in the Comey case, whether he already starts to put the parties to their paces about how soon they're ready to go to trial, whether they want to set up a motion schedule today. Not all judges do that at an arraignment, but in the Eastern District of Virginia, that is something you can expect at an initial arraignment like this, because these are judges who want to get the case moving, Allie.
So we're going to be looking to circle some potential dates on our calendar. But, Ken, let's dive a little deeper here, because just this morning, the Attorney General's legal team filed two documents, one of them with the intent to file a motion to try to disqualify Lindsay Halligan from her role as acting U.S. attorney. What do we know about that? And there's likely here a potential connection to the way that James Comey is also trying to argue that she's illegally in place, and thusly the trial and the motions that she's putting forward themselves shouldn't be happening, right?
That's right, Allie. At issue here is the Appointments Clause and whether the Trump administration is following the Federal Vacancies Act And they have an issue where they appoint people as U.S. attorney who can't be Senate confirmed. And so they need to install them on an interim basis. And the problem with that is you can only do that for so long. There's a 120-day limit in the law about that. And there already was an interim U.S. attorney in this district. As you mentioned, he's the person who was forced out because he didn't want to bring this case. And so the question is, does that 120-day clock start again for Lindsay Halligan? Is she even properly situated right now? Is she even legally the U.S. attorney? That's the question raised by this motion. It's not settled by the appeals courts yet, but it's one way that James's lawyers are attacking this case, and two other judges in other jurisdictions have ruled against the Trump administration in the case of other U.S. attorneys similarly situated. So a lot of legal experts think that this one has legs out.
And Ken, as you've been talking, we've been getting a little bit of information from our producer inside the courthouse. This trial has been set for January 2nd. And of course, James has entered the plea that we expected her team to enter, which is not guilty. We're going to continue waiting to hear from our team inside the courthouse for more communication on that. But Jill, when you hear that news that a trial date has been set, that the Attorney General has entered her not guilty plea, what do you see in that? Is that just kind of the way that we expected this to go? And what do you make of what's in front of the judge today between this hearing and the documents that have been filed by James's lawyer?
A couple of things. A criminal arraignment is a pro forma part of the criminal process. Every criminal defendant goes before a court, and they are told officially what they are charged with. In this case, what the indictment reads, and then they enter a plea. Obviously, if they don't have an attorney, one is always provided to them. This happens in every case. There's nothing unusual here. The unusual aspect is twofold. One is, of course, the press interest and the president's interest in this rather otherwise uninteresting case. And the second one, of course, is the propriety of the manner in which this was handled by the U.S. attorney, Miss Halligan, who they're looking at the efficacy and the appropriateness of her appointment. Remember, though, even if two things. One is if a federal district court says her appointment is inappropriate, that doesn't mean the case ends. It means this indictment may end, but it would be without prejudice, and someone could go back in who does have the authority to go into the grand jury to take this indictment. Again, it would just slow down the process. That could happen. So those are things to look at here in terms of whether and how quickly this case goes forward. You always adjourn the case for motions. You can set down a trial date, but it's not going to trial that quickly. Nothing, even on a rocket docket, goes that quickly.
This rocket moves a little bit more slowly than we would assume conventional rockets would move. I think that's an important point here. And to even amend what we thought we heard out of the courthouse, January 2nd right now is the proposed date. It is not yet set. And I think it's also important, as we're looking at our calendar now for that first week of the new year, that James Comey's trial has been set for January 5th. So this would all potentially happen within a few days of each other. And we've talked, Paul, about the ways that there are parallels between the Comey case and the ways that they are attempting to get it dismissed, and the way now that we're seeing Tish James's team orient themselves along a similar, if not slightly different, blueprint. What are you seeing here? What are you looking for? As we also keep an eye, I should note, on the other side of the screen, there's some microphones set up. We'll see if we see Tish James. She's been vocal in her own defense.
So both Comey and Tish James have very good selective and vindictive prosecution motions. Typically, those motions fail because you have to prove that the prosecutor has some kind of political or other ill motive, and there's no evidence. Here, there's a ton of evidence from the president and from the attorney general, the president saying that these people have to be prosecuted. We have career prosecutors saying to Bondi, we don't want to bring this case because we're going to lose. The evidence doesn't suggest that Comey is guilty of the crimes he's charged with, and the same thing with James, but they were overridden, and these prosecutions thus seem forced. So again, I think these motions for selective prosecution have a good chance of prevailing.
And we know that that's typically a harder argument to make. You and other legal experts that we're lucky enough to talk to all the time consistently make that point. And yet, when it comes to Comey, the fact that it's not just the attorneys in this case who have been talking in ways that we don't typically see U.S. attorneys speak. That's another thing that we'll dig into and have on this program. But then also the idea that the president himself has been so outspoken about the kinds of prosecutions that he wants to see his Department of Justice make. What does it tell you here, Anthony Coley, that along with Halligan, you've got other attorneys presenting this case, one DOJ attorney from Missouri. What does that tell you? Because our reporting from Ken and Carol Lenig and others has shown there is a lot of reluctance on the part of prosecutors in the Eastern District of Virginia to have even brought this case in the first place.
Right. It tells me that this case is laughably thin. And this is if we can even call it a case. I mean, when you think about the fact that there were a number of line prosecutors in the Eastern District of Virginia who said, no, I'm not going to touch this. And so, Ali, if we can go inside the U.S. Attorney's Office for a second.
Please.
So when there are hot cases in a U.S. Attorney's Office, lawyers are fighting over themselves to be the lead counsel.
Mm-hmm.
In this case, it was like, no, we don't want to touch it. It was almost like a case of hot potato, hot potato, hot potato. We are not going to touch this. But that is a tell because there is a standard in the Justice Department. Prosecutors are taught you only bring a case if there is enough evidence to obtain and sustain a conviction. That's not the case here. And it tells me they brought other people in because the people in the office just didn't have faith in this case. And they couldn't find anybody who had fidelity to DOJ's post-Watergate norms to do it, so they had to go outside the office to get it done.
This hearing was never just about Letitia James or Donald Trump. It's about whether the rule of law can survive when politics starts pulling the strings. Inside that courtroom, prosecutors are racing against their own credibility, and a young judge is trying to keep justice from being swallowed by headlines. If this case collapses under its own weight, it won't just embarrass a few lawyers. It will show how fragile truth becomes when power gets desperate. But if the evidence holds, if the process stands firm, then maybe justice still has a fighting chance. The danger here is normalization, when every legal battle turns into a political weapon and accountability becomes a matter of party lines instead of principles. America's justice system was built to outlast personalities, but only if people still care about facts more than spectacle. Trump may be celebrating, James may be defending, but history will ask a simpler question. Did truth win, or just survive? So what do you think? Let me know in the comments, and don't forget to subscribe for more breakdowns like this.